And the building owners have proposed arguments stating that they feel that because rent increases are not, either because of preferential rents or because building owners want to maximize on the rent they can collect from the lowest rented apartments, that they push for supplemental increases. One argument that we've made to dissuade that is to state that these are the lowest income residents who reside in the lowest rent apartments. But we also want to make the point that there are a substantial number of properties that have perhaps a very small percentage of rent stabilized units in comparison to decontrolled units within the larger properties. So I would hope that the board will consider, you will consider the friendly amendment that for properties larger than 30 units, that where 60% or more of the units are not regulated or are not controlled or non-rent stabilized, that for those buildings that they should not receive any increases.
Thank you. I reject that also.
Bloomberg rejects that.
What a surprise.
Bloomberg rejects that.
Okay, now call for a vote.
Chair, I actually have another question.
Yes, Mr. Epstein.
Yeah, I'm wondering about the idea of this balance of equities that we're trying to raise here, and the issue of the needs for the owners who have additional expenses versus the issue of tenant affordability. And I'm wondering if there are scenarios that you're talking about here where the owners are sufficiently making profit from the non-regulated units in their building, that there was any opportunity, whether 60% is the number or not, where there would be some sense where, like in the situation with the SROs, that there are so many market rate units in that building, that the ones that are left are just holding on, there would be any opportunity to have some kind of balance of not having a substantial increase for those units as well, as you're proposing as an across-the-board increase.
It is something that, again, is open to the testimony, but I'm not accepting any changes to my proposal at this point.
Yeah, I'm not asking for a change, I'm asking for an answer to a question.
The answer basically is we get the data, we listen to what people say.
You do not listen to what people
Yes,
say.
we do. Yes, we
No,
do.
you do not. You do whatever Bloomberg tells you to do.
We don't come with set minds here.
So you'd be open to,
Oh, what
Absolutely.
crap.
you're open to that possibility.
Contrary to what most people think, our minds are not made up when we come here, and our minds are not made up when we testify.
Yeah, right.
Your nose is getting big.
Thank you.
Thank you. Mr. Che. I vote no. Mr. Che votes no. Ms. Cruz.
No.
Ms. Cruz votes no. Mr. Epstein.
No.
Mr. Epstein votes no. Ms. Levy-Odom.
Yes.
Ms. Levy-Odom votes yes. Ms. Moore.
Yes.
Ms. Moore votes yes. Mr. Schleider.
Pass.
Mr. Schleider passes. Ms. Shine.
Yes.
Ms. Shine votes yes. Mr. Wank.
Yes.
Mr. Wank votes yes. Mr. Schleider.
No.
Mr. Schleider votes no. Chair votes yes. Motion passes 5-4.
What a
The
surprise.
rotten gang of bandits always supposed to raise the rent. The rotten gang of bandits always
We
supposed
will
to
now
raise the
turn
rent.
to the hotels.
It really is deja vu all over again. The script never changes.
Read the following language for adoption. New York City Rent Guidelines Board proposed 2013 Hotel Order number 43. Proposed order number 43, hotels, rooming houses, single-room occupancy buildings, and lodging houses. Rent levels to be effective for leases commencing October 1, 2013 through September 30th, 2014. Notice is hereby given pursuant to the authority vested in the New York City Rent Guidelines Board by the Rent Stabilization Law of 1969 as amended, and the Emergency Tenant Protection Act of 1974 as amended, implemented by Resolution number 276 of 1974 of the New York City Council and extended by Chapter 97 of the laws of 2011, and in accordance with the requirements of Section 1043 of the New York City Charter, that the Rent Guidelines Board hereby proposes the following levels of fair rent increases over lawful rents charged and paid on September 30th, 2013. Applicability. This order shall apply to units and buildings subject to the hotel section of the Rent Stabilization Law, sections 26504C and 26506 of the New York City Administrative Code as amended, or the Emergency Tenant Protection Act of 1974, Chapter 576 of the laws of 1974, Section 4, subsection 5A7. With respect to any tenant who has no lease or rental agreement, the level of rent increase established herein shall be effective as of 1 year from the date of the tenant's commencing occupancy, or as of 1 year from the date of the last rent adjustment charged to the tenant, or as of October 1, 2013, whichever is later. This anniversary date will also serve as the effective date for all subsequent Rent Guidelines Board hotel orders, unless the board shall specifically provide otherwise in the order. Where a lease or rental agreement is in effect, this order shall govern the rent increase applicable on or after October 1, 2013, upon expiration of such lease or rental agreement, but in no event prior to 1 year from the commencement date of the expiring lease, unless the parties have contracted to be bound by the effective date of this order. Proposed rent guidelines for hotels, rooming houses, single-room occupancy buildings, and lodging houses. Pursuant to its mandate to promulgate rent adjustments for hotel units subject to the Rent Stabilization Law of 1969, as amended, Section 26.510E of the New York City Administrative Code, the Rent Guidelines Board hereby proposes the following rent adjustments. The allowable level of rent adjustment over the lawful rent actually charged and paid on September 30th, 2013 shall be: for residential Class A apartment hotels, blank percent; lodging houses, blank percent; rooming houses, Class B buildings containing less than 30 units, blank percent; Class B hotels, blank percent; single-room occupancy buildings, multiple dwelling law section 248 SROs, blank percent. New tenancies proposal. Blank vacancy allowance is permitted under this order. Additional charges proposal. It is expressly understood that the rents collectible under the terms of this order are intended to compensate in full for all services provided without extra charge on the statutory date for the particular hotel dwelling unit or at the commencement of the tenancy and subsequent thereto. No additional charges may be made to a tenant for such services. However, such charges may be called or identified. Statement of basis and purpose. The Rent Guidelines Board is authorized to promulgate rent guidelines governing hotel units subject to the Rent Stabilization Law of 1969 as amended and the Emergency Tenant Protection Act of 1974 as amended. The purpose of these guidelines is to implement the public policy set forth in findings and declaration of emergency of the Rent Stabilization Law of 1969, Section 26.501 of the New York City Administrative Code, and the legislative finding contained in the Emergency Tenant Protection Act of 1974, Chapter 576 of the laws of 1974, Section 4, subsection 2. Dated April 30th, 2013. Jonathan Kimmel, Chair, New York City Rent Guidelines Board. I now open the floor. Ms. Cruz?
Yes.
Has a proposal?
Chairman, I propose that the rent adjustment over the lawful rent actually charged and paid on September 30th, 2013 for the following classes of hotel units: residential Class A apartment hotels, lodging houses, rooming houses, Class B hotels, and SRO be 3%.
Oh, wow.
In addition, I would move for a 10% vacancy allowance as permitted.
Wow.
Is there a second?
Second.
Of course.
Mr. Slaughter seconds. Is there discussion? Mr. Che?
I know last year that the building owner representatives themselves have introduced provisos regarding what classes of buildings may take these increases. And I hope that the building owners would also consider that this year in their suggestions for increases for hotels and SROs.
No, I don't consider it for the reasons that I don't think it is good public policy to create different types of housing just based on the fact that they are necessarily located in a building where some rents are higher than others. We are talking based on the regulated units in a building, and if the data that was presented to us justifies increases of managing and operating those units warrant an increase, then it should be proper to impose an increase for these tenants. And to argue, as you do, that those increased costs should be made up by market rents only serves to inflate market rents artificially, and I do not subscribe to that.
Pass the laugh test.
Thank you.
Yes.
I just want to speak on this issue as well. I mean, we heard unopposed testimony that said that any increase for this population means that they're just going to be out. And the idea that we think a hotel operator who still has 20 SRO units left in a 100-unit or 200-unit hotel, that the 3% increase changes the operating costs for them doesn't seem to work in my mind. It really is the difference between them eating or not. And here the difference for the owner is trying to get the tenant out or not that they need the costs in operating their buildings. Whether it's that they're getting $10,000 a month from the hotel unit, or $12,000 a month from the unit, or $8,000 a month from the unit, it makes no difference in relationship to what those SRO tenants are paying. The 3% doesn't make a difference to the owner, it only makes a difference to the tenant.
Further discussion? To 3%. There shall be no vacancy allowance under this order. Therefore, for rents charged for tenancies on or after October 1 and on or before September 30, 2014 may not exceed the levels over rentals charged on September 30, 2013. I also offer up the following hotel proviso. Except that the allowable level of rent adjustment over the lawful rent actually charged and paid on September 30, 2013 shall be 0% if permanent rent stabilized or rent controlled tenants paying no more than the legal regulated rent at the time that any rent increase in this order would otherwise be authorized constitute fewer than 85% of all units in a building that are used or occupied or intended, arranged, or designed to be used or occupied in whole or in part as the home, residence, or sleeping place of one or more human beings. Is there a second? Mr. Wayne seconds. Is there discussion? Hearing none, call for a vote. Mr. Che.
Chairman Kimmel, I just want to say I appreciate the range that you've provided because it does consider a 0% option for the hotel guidelines, and therefore I vote yes.
Mr. Che votes yes. Thank you. Ms. Cruz.
I'm going to pass.
Ms. Cruz passes. Mr. Epstein.
Chair, I actually appreciate that you require that 85% of the units be regularly rent stabilized units, and because of that, I would vote yes.
Mr. Epstein votes yes. Ms. Levy-Odom.
Yes.
Ms. Levy-Odom votes yes. Ms. Moore.
Yes.
Ms. Moore votes yes. Mr. Schleider.
I'll echo Mr. Epstein's sentiment that since we do have a chance of getting a 3% increase, vote yes on it.
Mr. Schleider votes yes. Ms. Shine.
Yes.
Ms. Shine votes yes. Mr. Wing.
Yes.
Mr. Wing votes yes. Ms. Cruz.
I will vote yes.
Ms. Cruz votes yes. Chair votes yes. Passes unanimously. 9-0. With that in mind, is there a motion to adjourn? Motion to adjourn. Is there a second? This meeting is adjourned. Thank you, everyone.
The rotten gang of bandits are supposed to pay the rent. The rotten gang of bandits are supposed to pay the rent. The rotten gang of bandits are supposed to pay the rent. Before I know it, my money's all been spent.